Federal Drive is presented by GEHA, Government Employees Health Association, proudly providing health and dental benefits to federal employees and their families. Visit GEHA.com.
Under Biden administration regulations, only contractors with a project labor agreement can bid on federal construction projects. Whether that's a good thing or a bad thing depends on what you measure. Here with more insight on the impact of PLAs is the legal director at the National Right to Work Foundation, William Messenger. Mr. Messenger, thank you for joining me today.
That's a pleasure to be here.
All right, we're going to talk about project labor agreements. Can you start by helping us understand what they are and when they get applied in federal projects?
Sure. A project labor agreement, often called a PLA, the acronym, is when the government requires that all contractors on a particular project be a party to a union collective bargaining agreement. So it basically requires the project to be union only. Every contractor, subcontractor, worker on the project has to agree to be bound by that union agreement.
And the Biden administration had some orders requiring that federal projects engage with PLAs, correct?
Yes, it started off with an executive order, and those were later put into federal regulations. And basically what they say is for large-scale construction projects, what they defined as over $35 million, there must be a project labor agreement unless the procurement officer finds an exception applies to that particular project.
And what are the impacts of that regulation, both pro and con?
Well, the con is that it interferes with the competitive bidding process, because normally under the competitive bidding process the government usually uses, everyone can solicit or submit a bid, and the procurement officer chooses the best bid, whether it be union or non-union. With the project labor agreement rule that the Biden administration put in, it basically said we're only going to accept bids with a project labor agreement or that would later agree to a project labor agreement. So the effect was either to basically exclude all non-union bidders from the project and in the same sense then exclude their non-union workforce.
But don't PLAs have an impact on the employees themselves in terms of higher wages and benefits?
Well, you're bound by the collective bargaining agreement, which has, it can have pros and cons depending on the agreement at issue. So you do have the wages set there. Some of the benefit packages, though, wouldn't inure to non-union employees because they would never actually vest for the pensions. And there's other negatives. So, for example, in non-right-to-work states, almost every project labor agreement will require the workers to pay dues to a union to work on that job. Most of them also require that every employee go through a union hiring hall in order to become employed on that project, which for people who aren't usually union is often impossible because hiring is done through hiring halls on a seniority basis.
So what is the status of PLAs kind of across the country? Are they more common, less common?
Less common. It really depends on the state, because what we're talking about here is when the government requires a project labor agreement as a condition of doing a project. So some states have banned government-mandated PLAs. Other states tend to try to require them. And here the legality of the Biden administration's project labor agreement requirement is being litigated and is still very much in doubt.
So the National Right to Work organization filed an amicus brief in that case. Can you tell us a little bit about what your arguments are and where the case is?
Sure. So the case, it's in the 11th Circuit Court of Appeals, which is basically Florida. The case was filed by Associated Builders and Contractors, also known as ABC, challenging the Biden administration's executive order on PLAs on a variety of grounds. We submitted an amicus brief in support of that legal challenge to the 11th Circuit Court of Appeals, and we made basically two arguments. First is that these project labor agreement requirements infringe on the First Amendment rights of non-union workers and merit shop contractors, and second, that the requirement is preempted by the National Labor Relations Act, which is the labor law that covers the vast majority of private sector workers and basically all construction workers. And the argument there is that the Biden administration wasn't free to basically interfere with labor relations on federal construction projects. Rather, the National Labor Relations Act sort of controls what workers and unions and employers can and cannot do on those projects.
I'm speaking with William Messenger. He's legal director at the National Right to Work Foundation. So what are the implications of this case as it goes through litigation? And I don't know if you have any foresight as to where you think the decision might be heading, but how does it play out on the ground with construction companies, with projects, and with people?
Well, as it's being implemented, the presumption now is that you must have a project labor agreement on a contract, any federal construction project worth more than $35 million. The Trump administration tried to issue blanket waivers to this rule, the Department of Defense and GSA, saying, we're basically saying the exception always applies. We won't require a PLA. Unfortunately, that was enjoined by a district court that says, no, you can only do exceptions on a case-by-case basis. In the wake of that, the Trump administration says, well, the regulations are what they are at present. Therefore, we're going to require PLAs unless one of these narrow exceptions applies. Now, we'll see if the Trump administration later decides to rescind those regulations, which would require going through notice of rulemaking. That's an unknown. But what is known is there is this legal challenge at the 11th Circuit. The district court actually found that the order was likely illegal, but refused to preliminarily enjoin it. So that's the issue on appeal at the 11th Circuit. If the 11th Circuit says this order, the PLA rule is illegal, which, again, it probably is on a variety of grounds, then that would effectively strike down the rules and regulations and free, workers and merit shop contractors from these PLA requirements on federal projects.
So during the Biden administration, Congress appropriated billions of dollars for infrastructure projects. Is this uncertainty about the PLA provision holding any of those projects up at this point?
Not to my knowledge. It did slow down a few. So there was another group of challenges to this project labor agreement mandate by 12 construction contractors who were basically awarded the projects, and then they had them ripped away from them because they say they didn't have PLAs. So the Court of Federal Claims actually said that was illegal. It violates the competitive bidding law with respect to those bidders, and then in the wake of that, they basically changed the solicitations back to award the contracts to the best bidder without a project labor agreement requirement. So it is possible that requiring the PLAs, especially moving forward, will interfere with procurement of contractors on federal construction projects.
So often in the federal management space, when we talk about contractors, we're talking about weapons systems or service providers or consultancies. We don't often talk about the construction contracts that are federally issued. So talk a little more about that business environment. How is this, again, uncertainty affecting the market for federal construction contractors?
Sure. As the PLA rule is, creating just a large impediment to having bids on these projects. So sort of moving forward, if you require a project labor agreement, it basically means that merit shop contractors won't bid on that project. And that's the vast majority. So 90% of construction workers in America are non-union. The number of construction workers, again, is 10%. So if you're excluding the vast majority of construction workers from even bidding on these federal construction projects, that significantly limits competition and may make it more difficult for agencies to find a bidder for a project, or for that matter, to find the best bidder for a project by basically rigging the bidding process to exclude merit shop bids and only effectively allowing union bids.
When you say merit shop bids, my mind is equating that with small businesses. Is that fair?
A merit shop refers to contractors that are non-union because they base upon, the merit of their work and the bids they put in, as opposed to saying we're entitled to this bid because we're a unionized contractor. So in the construction space, merit shop is often used to mean non-union contractors.
Does the PLA regulation as it's currently written have the effect of incentivizing construction contractors to actually implement union contracts, or are many resisting it because it's so complicated and difficult?
Many just won't bid. Merit shop just won't bid in the first place because, again, if the Biden rule basically requires there must be a PLA unless a certain narrow exception applies on a case-by-case basis. So there are some exceptions to enforcing it, but the way it's set up, it creates a strong presumption for them, which is a change from what was before. So the Obama administration also issued a rule regarding project labor agreements that said procurement agencies can use a project labor agreement if they want to, if they find it's efficient, but they don't have to if they find it's not efficient. Only about 0.04% over 15 years did the procurement agency actually find that the project labor agreement was in the best interests of the procurement project at issue. It was 12 out of 3,222 projects between 2009 and 2022 that the agencies actually said, oh yeah, a project labor agreement's a good idea here. So they were almost never used. But then the Biden administration comes along and basically flips everything on its head and says, no, project labor agreement's the default rule, absent an exception.
So I asked you a little bit earlier to prognosticate about the outcome of the case, given that it's kind of moving its way through the court system and will always be eligible for appeal up to a certain point. how should the contracting environment or the contracting market respond now while these court cases are going on?
I would think that merit shop contractors would continue to challenge individual bids that do have a project labor agreement. As of now, there's not certainty as to whether or not the PLA rule is illegal. As we said, it's before the 11th Circuit, but that wouldn't stop contractors from filing their own independent objections to these requirements on a project-by-project basis. And again, that's what happened in that earlier case I referred to, where 12 contractors said, hey, what you did to us by requiring a project labor agreement violated the Competition and Contracting Act. Court of Federal Claims agreed. Almost any other contractor could more or less do the same thing again if they're forced to submit to a project labor agreement. But, the 11th Circuit's moving on an expedited basis, so it's possible we might have a decision in a few months from the 11th Circuit. And if the 11th Circuit strikes down the entire rule, that resolves the problem.
I've been speaking with William Messenger. He's the legal director at the National Right to Work Foundation. Mr. Messenger, thank you so much for sharing your insights on this really interesting and important legal case that's going on.
Oh, thank you for having me. I really appreciate it.
We'll post this interview at federalnewsnetwork.com/Federal Drive. Subscribe to the Federal Drive wherever you get your podcasts.